This means I'm supposed to turn on the mic. Did I turn it on correctly? Woo! All right, we are started well. Welcome, everyone. I am Amy Wildermuth. I'm the dean here at Pitt Law, and we are thrilled to host this event for Constitution Day. But before I go any farther, I want to be sure that we thank the people who put this all together. So I hope you will join me in thanking both Professor Brake, who's up here in the front, and Deb Hilton, who's in the back, for putting this together. It really is a fantastic program we have in store. So Constitution Day commemorates the signing of our Constitution on this day 230 years ago. It is a time for us to learn more and reflect on the words and the spirit of that document. Over the many years of our grand American experiment, the Constitution and the debates around it have reflected much of how we as a nation have struggled and changed over time in our collective quest for justice and a more just society. And in this way, this event and others like it can inspire us. In fact, just a short 30 years ago, I was part of Rich East High School's team that participated in the bicentennial of the Constitution competition. Say that a lot of times quickly, right? And we ended up as the state champion for the state of Illinois, which is something that folks from Rich East High School did not often accomplish. And that competition, more than anything else, including my parents telling me on several occasions as a child that I did not have to make a federal case out of everything, was why I have the privilege to stand before you today. We are so very fortunate and delighted to have with us one of those people who not only enrich our understanding of the Constitution, but inspire in big and small ways all of us toward a more just society. Professor Victoria Nourse. Professor Nourse is the Ralph V. Whitworth, I'm going to get it correct one of these times, professor in law at Georgetown University Law Center. She is also the director of the Center on Congressional Studies. Before joining the faculty at Georgetown, she was a chaired professor at both the University of Wisconsin Law School, go Badgers, and Emory School of Law. She is a leading national scholar of the separation of powers and constitutional limits of executive power. She's authored numerous law review articles and books, including one we learned last night that was optioned to be a film. Wow. Her latest book, Misreading Law, Misreading Democracy, was published in 2016 by Harvard University Press. And not one to ever slow down, she has at least one or possibly two other books on the way. In addition to her academic career, Professor Nourse has had a distinguished career in public service, including serving as Chief Counsel to Vice President Biden, and prior to that, as Special Counsel to the Judiciary Committee. Among her many accomplishments and achievements, she was, according to Professor Brake, the mastermind behind and the lead drafter of the Violence Against Women Act and its civil rights remedy for gender-motivated violence. We are so fortunate to have you here with us today. Please join me in welcoming Professor Nourse to Pitt Law. Thank you.
Well, I'm so honored to be here today. I have never been to Pittsburgh, and it is lovely. It really is. I'm happy to be out of the swamp, as they say. So thank you to the Dean and Associate Dean Brake, and to all at Pitt Law who've made this possible for me to come up and enjoy a beautiful day in Pittsburgh. I've never been asked to give a Constitution Day address. And I hope that this will be both enlightening and as well will give you some sense about the importance of our Constitution today. Many students go to constitutional law and they think, oh, I'm going to learn about abortion and rights, and I'm going to learn about, well, I don't know, the First Amendment. And I have to disappoint them because what I study is structure, and there is no more important time than now to remember a few things about our constitutional structure. So let me just say that this should be a great day. Our Constitution has been the model of government the world over since World War II. It has been a beacon of light, of freedom, and redemption. It represents a powerful idea, as the dean suggested, that people have fought and died for, to save what Lincoln called the last best hope on earth. Constitution Days are occasions to reflect upon the fundamentals. For too many, I'm afraid, today, the Constitution remains a vision rather than a reality. Abigail Adams' 200-year-old or over 200-year-old injunction to remember the ladies, which was met by her husband with a bit of, oh, how funny, remains an unrealized constitutional vision for a majority of Americans. The legacy of 1619, the date the first African American was brought to this land in shackles, clouds the dreams of small children. And for immigrants, fear, not hope, looms in grossly palpable forms as they watch Hispanics and others bleed to death in parking lots, victims of mass shootings that you know all too well here in Pittsburgh. That's a pretty bleak picture. If there's a silver lining, it is that we are engaged in an intense national debate. I thought on such a beautiful day I'd have 5 people to speak to. You've rejected the weather to come here because you are asking questions. Our constitutional structure is under stress, but we are persevering, debating, entertaining what seem like 700 presidential candidates. They can't even fit on a single stage. Both Republicans and Democrats are preparing early and insistently for what sits at the heart of my vision of the Constitution, and it's pretty darn simple. It's called elections. And we do that even knowing that there is a risk. I never thought I would say this, but we know now that foreign powers tried to interfere with this most precious of constitutional rights in 2016. If there's nothing else I say today, you should remember this. In my lifetime, and I get to say this now that I'm almost a senior citizen, in my lifetime, this nation has never been under the cloud of such foreign interference. Technology has given us so many gifts, but it has also given us a danger. So cherish what you have taken for granted, what I have taken for granted. Free and fair elections, because that is at the heart of our Constitution. Now, constitutional law courses, and I get into debates with all of my many colleagues. We have the largest law faculty, I think, other than Harvard in the country. Lots of different views about how to teach constitutional law. The thing is, most of them don't start with elections. Students learn about some parts of the Constitution in excruciating detail. How many constitutional law students do I have here? Oh, man. Actually, this is why I accepted this invitation, because I thought people from the university would come, because this is so I'll give you the Article 1, Section 8 is really big. That's about commerce and spending. And then there are the amendments. Of course, they weren't even in the original Constitution. And then they learn a lot of sort of jargon about how courts treat these. There are special kinds of words like strict scrutiny and rational basis that are the stuff of law school exams. And I push back on that, mostly because, and I do teach all of that, but I do it within a different frame. Because mostly what people teach in constitutional law is the law of courts, our Supreme Court, and the fancy phrases they use. But that's not our entire Constitution. And it's certainly not what the Constitution does. It's action, the heart of how we govern ourselves. In fact, I'm pretty aggressive about saying that courts are not the center of our Constitution, that it is deeply misleading to teach the Constitution in this way, And if there are any constitutionalists or a few faculty here, they know that famously oftentimes constitutional law courses begin with Marbury versus Madison, to be revered because, which was actually an important separation of powers case, but it was one in which is known to establish judicial review, which, by the way, actually existed long before that, but I digress. In Marbury, the court, and the court still quotes this, it is for the judges to say what the law is. Now, having had the wonderful experience of working on both sides of Pennsylvania Avenue, I can tell you that if you ask a president, or if you ask a senator or a House member, they will say, I say what the law is. I make the laws. I create them. I sign them. If this is correct, I think we must see the Constitution and its separation of powers as something more than legal details. This is why elections are at the heart of my Constitution. Which brings me to the title of this lecture, The Oligarch's Road. Oligarchy means rule by the few, not the many. Oligarchies have often been our enemies. Think Russia, China, Iran. These countries are the ones we reject as following systems of government antithetical to our own. So now my claim today is not that America has become an oligarchy yet. It is to consider the conditions that paved the road to oligarchy. There is no one path that countries have taken there, but I can tell you one sure way to achieve it, and that is to eliminate self-rule, to undercut the power of the people, make leaders immune from accountability from the people, and at its most extreme, put the opposition and press in jail. Lock them up. One does not need to get rid of elections. You can see this in many oligarchies. One need only control the electoral machinery and make people believe that rule by the few is in their interest and legitimate. Now, lest I seem extreme, I will invoke George Washington on this day. He too feared oligarchies. He warned that the spirit of warring parties, what he called faction, would sharpen revenge and would in turn lead to a more formal despotism of the one or the few. Excuse me. In his farewell address, which I recommend to you all, as he left the White House, he warned the disorders and miseries which result from this revengeful partisanship gradually incline the minds of men to seek security and repose in the absolute power of an individual. And sooner or later, the chief of some prevailing faction, more able or more fortunate than his competitors, turns this disposition to the purposes of his own elevation on the ruins of public liberty. A decade ago, it would have seemed a fringe argument, slightly crazy to talk about oligarchy in America. But in the past 10 years, we have heard the warnings. Economists tell us that rising income inequality means that we are operating in a de facto plutocracy, meaning ruled by the rich, in which the top 1% wield their power to enrich themselves. Political scientists have warned that our electoral structure is threatened by massive amounts of money in politics, and perhaps worse, partisan gerrymandering, drawing the lines of an electoral district for the precise purpose of rigging the outcome, even if that yields rule by a minority of American voters. Now, critics will say those complaints are about the economy, or they're about parties. Where is the oligarchy? Before I answer, I just want to make one point of privilege, as they say in the Senate. I'm going to digress long enough to say that I am often shocked about American lawyers' ignorance of the way in which our government is actually ruled, in many cases already by powerful minorities. Once, many years ago, I was at a conference at Harvard on reforming legal education. I was very privileged to be invited. And I asked the rather impressive audience, because I was pitching, that we need civics. Civics is no longer taught in political science departments. My husband's a political scientist, if there are any in the room. I'm okay with political science. They teach econometrics now. They don't teach civics. And like Justice O'Connor and Justice Sotomayor now, I have been pushing for a while that law schools really need to give an introductory one-week course in basic civics, because not everybody coming to law school increasingly has studied that. Like me, maybe they studied engineering. That's what I studied at Stanford. So I asked the room with all these impressive people, what is the most important rule in democracy? No one raised their hand. To break the awkward silence, I said, well, I'll give you the number of the rule. It's 22, because we lawyers like to talk about numbers, you know, section 6103 of the tax code, that kind of stuff. Gave him a number, 22. Now, someone raised his hand from the back of the room and said, interpleader. All the lawyers are laughing because this is a rule of civil procedure known to litigants in courts. And what I was trying to talk about was the whole Constitution, the one where we get the power to vote, to elect our representatives, not the rules that govern courts, because that's why I was there, to try to argue for civics education about the Congress and the president. So, interpleader is not, as you guess, the most important rule of democracy. The most important rule that has the number 22 is a rule in the Senate. That rule says it takes 60 votes to pass any piece of legislation. It is the rule that allows cloture on any filibuster, but today the practice of the filibuster is simply a threat of a filibuster by any single senator. We have a perpetual filibuster, even though you don't see it, even though there's no Jimmy Stewart, they're not reading the telephone book, none of that stuff. One person goes to Mitch McConnell or Chuck Schumer, whoever it is, says, I object. That's a filibuster now. If that person can launch or has the threat of launching enough votes, then you got to get 60. Now, that's not economics, right? And that's not political parties, that's structure. And that structure is increasingly coming, even in this election, to be debated, as Senator Warren and others have called for the elimination of the legislative filibuster. We have already eliminated it for judges and the Supreme Court. 51 votes, you get a Supreme Court justice. But you need 60 votes to get immigration reform, gun reform, a wall, whatever your preference is. Now, I've described now the conditions that make majority rule very difficult, but not impossible. Economic inequality, money in politics, partisan gerrymandering, and structured supermajority rules. But they've existed for some time. They've existed before this president. Which brings us to what I believe is different about this presidency and what it may contribute to the road to oligarchy. And the surprising answer here is the law. Law is the means by which economic trends or irregular practices or even norm bashing becomes rigidified and normalized, legitimated for everyone. The conditions that I've described have put stress on our structure, but to really change the structure, you would have to convince people that your change was legitimate, that it was lawful, that it was constitutional. Enter the president's lawyers and their vision of America's separation of powers. When I went to law school, the constitutional law of the separation of powers was settled. In 1952, President Truman decided he could seize some steel mills. Congress said, well, you can follow this procedure. And he said, no, I'm not going to follow your procedure. Went up to the court, and the court said, no, President Truman, you cannot ignore Congress. You cannot go seize some steel mills, even if it's for the Korean War. Justice Jackson, who had served at Nuremberg, the Nazi trials, wrote a celebrated opinion in which he famously talked of our government as enjoying shared as well as separated powers. This is the kind of thing that gives makes law students' brains explode. Shared but separated. What does that mean? It seems like an oxymoron. Well, it reflects an important truth. Without shared power, the departments really cannot check each other. Jackson gave us an understanding in which the Constitution presumes that it is safer for all of us if the Congress and the President agrees. I remember when George H.W. Bush sent his generals when the war in Kuwait, to the Congress. Congress stopped. 100 senators were sitting in their chairs. Very rarely do it. The generals came in, they passed a resolution for the Kuwait War. That was George H.W. Bush. That is the presumption that Jackson enshrined in his celebrated concurring opinion. Now, Jackson wasn't naive. He'd been Attorney General. He knew that all presidents, when frustrated, emphasis all, pushed the limits. FDR tried to pack the court. Lincoln issued the Emancipation Proclamation not for equality, but as a war measure. Obama directed sweeping immigration measures, knowing that they were subject to constitutional attack. But Justice Jackson also knew that the rule that the court announced could not be what President Truman's lawyers were arguing. The Solicitor General had argued, in the case that no law students generally read, that the president has all executive power, even in war. And Truman said, no, that's dangerous. He called it, his word, totalitarian. Jackson's vision of shared power has been under attack, however, since President Reagan. One of the earliest legal projects of the Federalist Society, and I say this with some affection for certain members of the Federalist Society. I appear there often, just as I do the American Constitution Society. But a part of that society believes we need a stronger presidency, and they've been building the constitutional argument since Reagan. It has come to be known as the doctrine of the unitary executive. That's how lawyers describe it. The source of the theory is an opinion written by Justice Scalia, a dissenting opinion, a single vote. And in that opinion, he wrote, to repeat, Article 2, Section 1, Clause 1 of the Constitution provides, quote, the executive power shall be vested in a President of the United States. As I, Justice Scalia, described at the outset of this opinion, this does not mean some of the executive power, but all of the executive power. Now, Justice Scalia was a textualist, meaning that he cared very much about the text of the Constitution, but in this case, he got it desperately wrong. The Constitution doesn't say all executive power. It says, in fact, it says all legislative powers in Article 1 for the Congress. He's added that. It's a small set of words, all executive power, but it packs a punch, and this is the problem. When you take that word out of an opinion, particularly a dissenting opinion, and you send it down Pennsylvania Avenue to the lawyers inside the White House. Now, many thought the unitary executive was dead after the War on Terror. President Bush had used this to justify extreme measures, including torture. The Office of Legal Counsel issued an opinion not citing steel seizure, the Truman case, and the lawyer was fired. New lawyer, the Justice Department withdrew the opinion, and ultimately, in a series of cases involving Guantanamo, the unitary executive theory was rejected by our Supreme Court. A series of cases. Now, despite all of this, now folly is defined by doing something you know has failed once, or twice, or 3 times. But guess what? The Trump administration's lawyers, including the lawyers inside the Justice Department and his personal lawyers, and then his White House counsel, so he's got a lot of lawyers, have revived the unitary executive. The post-Guantanamo unitary executive holds, first, that the president must have complete control over all executive branch agencies. That means the administrative state, like the EPA or the Federal Reserve or the Securities and Exchange Commission, the Commerce Department. Congress, they say, cannot limit the president's power over those agencies, which it often does to prevent political control. Congress says, we want you to be independent. So we're not going to let the president fire you for a bad reason. We don't like you, Janet Yellen, who was the former head of the Federal Reserve. We don't like your hair color. We don't like who you are. We don't like if you're a Democrat. Get rid of you. No, Congress says we can protect people from that kind of political reprisal. Oftentimes, independent agencies are independent because they deal with things for which we need expertise. The Federal Reserve is actually the jewel in the crown of financial institutions across the world. It is an independent agency by some means. The Nuclear Regulatory Agency, you'd think, you want that to be independent, right? You want some expertise there. Securities and Exchange Commission, also known throughout the world for its ability to keep markets stable and securities exchanges truthful. The new unitary executive tells the president he should have complete control over these agencies. Well, if this is what your lawyer is telling you, that you have all executive power, is it any surprise what we have seen? Most famously, the president was insistent over and over again, I can fire Robert Mueller. But it didn't stop there. He has repeatedly said he wants to direct the Federal Reserve to set interest rates. He has instructed his agents to ask about citizenship on the census, even though Congress doesn't want it, and the court said the process was irregular. I think he's withdrawn that. But then he attempted to tell the National Weather Service the direction of a hurricane. That the unitary executive is alive and well is no more clear than in the final cases I'll talk about, which are the fights going on in Washington between Congress and the president. Because the president has refused to cooperate with Congress, by the way, that's unusual. The norm is to cooperate. Even Ronald Reagan cooperated. We have fights in the courts about whether Congress has this subpoena power. Now, that power is well established. I mean, this is a much easier case than all the rest I've talked about. The Supreme Court has written that the power of Congress to conduct investigations is inherent in the legislative process. They've called it essential. They've upheld it since Teapot Dome, 1927. And the reason no president is above congressional investigation is because the president serves the people, not the reverse. Interestingly, the president's lawyers in the subpoena cases, particularly the ones about his financial records, are arguing that Congress has no power to investigate him. Every other citizen, by the way, can be subpoenaed by Congress. In one case, this is the case involving the accountants, and these are documents he created before he took office, so there's no claim of executive privilege. The lawyers are arguing that Congress is really prosecuting. Prosecutions are executive, and therefore reside within the president's own powers. The only one who can obtain these precedents is the president himself. Remember, as Justice Scalia said in dissent, the president has all executive power. As the lawyer for the House of Representatives, who was a former mentor in the Department of Justice of mine when I argued appellate cases, and a longtime career official who used to reject my briefs because I came from a very aggressive New York law firm, and he would, we don't do that at the Department of Justice, too aggressive, rewrite. He has said in his reply brief in the case in New York, the president's arguments are, quote, astounding. There's 100 years of law that says Congress, if it has a legitimate purpose, and that includes the purpose of inquiry and proposed legislation, any legislation you could possibly think of. In this case, they could be enforcing the Emoluments Clause, they could be protecting against corruption, or even foreign influence, if that is shown in some of these documents. So there's really no doubt, as one district court judge has already held in DC, that Congress has a legitimate purpose here. So what does this mean? The road to oligarchy, in my view, is built by those who are complicit in legitimizing it. And it is my fervent hope you are going to see this clash. The president will not comply with a court order from the Second Circuit or the DC Circuit, which will come down in 6 to 8 months, in my opinion, because the law is so clear. It will go to the Supreme Court, and we will have the biggest clash on the separation of powers since 1952. I don't know what this court will do. I do know that the theory of the unitary executive is something that Justice Kavanaugh has embraced. He has argued that the president, quote, alone, this is in a dissent in the DC Circuit, is in charge of the executive branch. But it is my hope that better angels will prevail. on the court, that these lawyers will be deemed as folks arguing things that we have rejected over and over and over again. It is time for lawyers to stand up and say what is on the wall, what is off the wall, and that these arguments are off the wall. Our system is under stress, and what I want to leave you with is, though, it is not broken. We do not have an oligarchy yet. There have been worse times. I wrote a book, yes, optioned as a movie, about some prisoners who brought a lawsuit all the way to the Supreme Court, challenging the notion of eugenics. I hate to tell you this, but we gave eugenics to the Nazis. They were to be sterilized. Inside a prison, they did their own studies. They found a lawyer who taught himself how to read law, and they took their case to the Supreme Court, and they won in 1942. There have been worse times. Bread lines, dust flying from western Colorado all the way to Chicago. Little children who died in the basement in 1963. But we must remember a spirit of constitutionalism that is unleashed by a document whose core is self-rule. History tells us that elections can transform the world in a way that judicial decisions cannot. Out of the rubble of that 16th Street basement came the 1964 Civil Rights Act, without which I would not be standing here, and many of the people in the room would not be here. Out of the bread lines came limits on child labor, Social Security, the rights of unions, limits on hours of work. Perhaps out of recent massacres, we will come to a new understanding. The words may be fixed, as originalists say, but the people who vote are not. As FDR, at a different year of crisis in 1937, at the height of a depression that seemed never to go away, he said this in his own Constitution Day address. For us, the Constitution is a common bond. We revere it not because it is old, but because it is ever new, not in the worship of its past alone, but in the faith of the living, who keep it young, now and in the years to come. These words have been derided as creating a poor rule for courts. But Roosevelt was not speaking to courts. He was speaking to the people, as he should be on Constitution Day. Thank you very much.
Okay, so we can open it up for some questions. Anybody have any questions? Oh.
Sorry, but I do have a comment. Can you hear me?
Yep.
Yeah. Okay. You mentioned civics, right?
Yes.
I remember I went to a one-room schoolhouse in Northern California, okay? In order to get from that 8th grade into high school, we had to pass not only a California history class, but we had to pass a U.S. Constitution civics history, right? Mm-hmm. So, and moving forward, it seems like this whole thing of civics, not just in law school, but all the way through grade school, is like if somebody would start teaching the Constitution again at a young age, maybe there would be a clearer understanding than what is spouted all over the place now. So I'd say, I think we need to start younger than law school.
I agree with you. In fact, as I think I adverted to this, after she left the court, retired, Justice O'Connor created a program, and she actually has online materials for teachers. So you don't have to create your own lesson plan. You can just pull it off the web. Now Justice Sotomayor has taken over that project for which Justice O'Connor had raised money. And you may know, someone here may know more about it than I do, but I think it's a wonderful project. And I do think, my daughter actually had one of the greatest classes. She went to a school in Wisconsin. The 6th grade history teacher was one of the best teachers I've ever seen in my entire life. Like, I've never seen a law professor anywhere near as good as this guy. He made them take a bar exam. They had to learn about but they were excited. They're 6th graders. They're not jaded yet by middle school. And so my daughter still remembers, we get into arguments, she wants to be a doctor. She's like, law, I want to help people with, diseases, Mom. Well, great for her, but she still remembers this. And she can put up a pretty good, legal argument for some things. Trust me, I know. But I do agree with you, we need to start earlier. And I've been trying to figure out ways in which maybe I could get law students to partner, with that initiative. Because they love to teach. The way you learn things is by teaching. So I think that might be a good thing to get them out to the schools in DC, something like that, because generally the students at Georgetown are very public interest oriented. But thank you for your comment.
Right. Another question. While we're waiting for that question, I'll just do an advertisement for the Marshall Brennan Scholars here at Pitt, and there are some, I believe, at Georgetown as well, that go out into high schools and do a lot of this work. So in case you're a Pitt Law student and you're looking for an opportunity like this, we have one. How's that?
Great.
All right.
I came to the right place today.
We got another question right here. Okay.
Thank you. It's easy to get demoralized in this important time. I hear your message about voting and elections, but there's also a cynic inside many of our heads saying, will it really matter? Is there such a transcendent threat that my vote will be counted, especially here in Pennsylvania? Welcome to Pittsburgh, but especially here in Pennsylvania where they say, oh, the road to the White House runs. So what's your advice when the most we do as advocates is vote?
Well, as I say, I think we should cherish it. We should have voting parties. We should actually embrace it with a positive spin. There are many good, fine people in America, whether they are in this administration or in state systems, who the states actually control the electoral systems. So that's another thing you can do. I'm going to have a voting party myself, invite all my students. But, I think we should embrace that. I think we should cherish it. And if you have concerns, bring them to your state. I know you think the feds control this, but they don't really. The states have, and in some ways that's good and bad. In other words, we have too much disunity. But the heads of the state election boards meet all the time. They have been aware of this since 2016. And they have been working on it tirelessly. We also have massive numbers of forces in agencies, some of which I once got a security clearance and someone told me I couldn't even name the agency, like it's so secret, There are people working on this, cybersecurity. And that they believe that's their mission, to protect America. And my stepdaughter's boyfriend is a former Navy SEAL, and that's what he works on now. He's the different battlefield. The bureaucracy in Washington kind of operates on its own. Many presidents realize when they come to office that they don't have as much power as they think, because there is an administrative state, and that remains continuous. So I worked for the Meese, Attorney General Meese, right? I was just a career lawyer. The career people there are civil servants, and they do these jobs because they believe that they are serving the public. So I'm not unoptimistic about the protections. I do think if you are concerned, use the paper ballot, talk to your Secretary of State who deals with elections. Hold a forum at Pitt. Try to make sure they know that people are watching. Excellent question. Thank you so much. It is demoralizing. I tried to write an upbeat speech, but it wasn't really writing very well for me.
Okay. You're good.
Yes, sir.
Many people say we really don't want to get political discussions in our friendships and stuff like that. I disagree. I think proselytizing for a cause you believe in, I think, is essential. There used to be, throughout American history, a very, very spirited debates, sometimes leading to violence. But the fact is, we're now trying to say, well, no, I don't want to get into politics tonight. I think we need to, because literally how we govern ourselves is determined by that process. And I think if each person would take it on themselves to try to convert one other person, that's how progress is made. It's made in millions of little increments.
Well, now I have my mission, because my brother-in-law, who grew up near Pittsburgh, It's not necessarily on my page, right? And so maybe you're right. I mean, I know that Americans, one of the beauties of America is it really doesn't care that much about politics. Not like the French or the Germans. Parliamentary democracy, they have parties like the Green Party and this party. We like to think we're all in it together, that we really don't disagree. And frankly, I'm hopeful because I think, 90% of people actually agree on a lot of issues. They don't agree on politics, and they like to not talk about it. You're absolutely right. And I think it may be one of those points in history, and we've had a few of those, where we really have to engage rather than retreat. So I don't know when I go home whether I'm going to, convert my brother-in-law, but I'll try for you. How's that? All right.
I know Professor Allen has a question.
I just wanted to say that there actually are structural ways for everyone to get involved in elections. I mean, when you go to your polling place, you see people, probably your neighbors, sitting behind the table. You see people directing people. You can go on the state website of Pennsylvania, you can go on the Allegheny County website, and there are programs that don't take a lot of time, and you can become one of those people. You can be a polling place monitor, a judge of elections. You need the day of Election Day, and with the wonderful support of our deans, we're going to institute a pro bono day at Pitt Law on Election Day next year that will allow law students to do that kind of work. As a matter of fact, you get paid $100 in Allegheny County for being one of those people at the polling place. And usually there are these retired people who are serving day in and day out. They're my neighbors 3 doors down, same guy's always there. We're always short of people. They need more people. On top of that, there's a nationwide program called Election Protection that's run by a nonpartisan organization out of DC. You can get involved in that and be a citizen who goes around on the outside wearing a t-shirt saying everybody has a right to vote and listening to people who are coming out of the polls to find out if there are problems. Of course, you're not going to be inside the database to see the Russian manipulation, but trust me, there are plenty of other ways that elections go wrong that you can see with your eyes and fix with a phone call to the election board when somebody's name isn't coming up. So if you're really serious about wanting to be more engaged in this great electoral structure, there really are ways. All you need is a little bit of time.
Thank you. Professor Allen has worked for a good bit of her career on wonderful issues involving voting rights, and so thank you for that. I think there are many, many programs that are out there. Obviously, we can't all become cyber warriors, but there are plenty of them in Washington, let me tell you.
Thank you. This is on. As you can tell, I am from one of those other countries that has a parliamentary system, and I've always been perplexed about, I love the comparative angle of comparative law. This may be outside the scope of what you wanted to talk about in terms of elections, but in terms of who wields what power, I wonder if you would like to say a few words about the Senate confirmation process in light of your comment about what the court will do if these questions come before the court, because we do see a really weird sort of legislative, executive, judicial mushing kind of there.
I didn't have time to go into all of the potential permutations, but you have highlighted something that's deeply problematic. The president has put on the bench through a confirmation process that is now only 51 votes, highly partisan, and in the last case with Justice Kavanaugh, also subject to lots of other allegations of improper behavior. And the question is, in an oligarchy, if these were the president's men, they're just going to vote for the president, right? And that is very difficult. That's why we have the worst possible system now, where we have 51 votes for our Supreme Court, but we can't get a piece of legislation through without 60. That is the worst possible system, which is why the pressure on the filibuster is enormous now. So if the next president, whoever the next president is, Republican or not, this president has urged to get rid of the filibuster, right? Yeah. No one wants to do it because they think they'll need it. They also believe, just to explain this, because it might seem, is it Australia or New Zealand? Australia. We should all go there because they have mandatory voting. Yes. You know, like that? All right, well, we can talk about that. At least we should have a day off. I think there's a bill pending in Congress. We should have a voting day, right? So that people don't have to worry about, being punished at their workplaces if they take too much time. They could get stuck at the polls, for no good reason. In any event, there will be a lot of pressure if whether a Republican or Democratic president will, in fact, feel pressure to get things done, in which case they will put pressure on, if there are 51 senators of that party, so let's say a Democratic president, 51 Democrats, a Republican president, 51 Republicans, there will be pressure to eliminate the filibuster. I personally think, given the current system, that we have to experiment with it. There are many possibilities about how to get rid of it. You could get rid of it, say, for things that have been lingering for, over 2 congressional terms or 4 congressional terms or something like that, like things that people know, just guns, immigration. There's been no movement, right? We need a vote, right? And that's what the minority leader, whether it's Chuck Schumer or Mitch McConnell, has done. Mitch McConnell has taken this to a new art in terms of his leadership. He doesn't really care about the other side at all. So, I think at this point, Harry Reid, formerly of Nevada, has gone on record saying he's now ready to get rid of the filibuster. The inside story about why senators love the filibuster is that they believe, as in the old analogy between a teacup and a saucer, that the teacup is boiling hot and that the Senate operates like the saucer. It cools the heated passions of the masses in the House. But they didn't imagine a constant filibuster. Aaron Burr is why we have this situation. I'm not kidding. Aaron Burr took Jefferson's Rules of Order, and he forgot to include motion for a previous question. So if you didn't like him before, really don't like him now, because he messed up the whole government. In a faculty meeting or in the House, you can say, let's stop debate, and then there's a vote on stopping debate. But the Senate doesn't operate that way, and it used to be that this was used only by Southern segregationists. So it was tarnished with the horrible norms behind it. But beginning in the 90s, when I actually was working in the Senate, it became constant. I mean, I have a friend who came out of that. I think the name of his lobbying firm is Getting to 60. So I do think there'll be pressure. The one thing that I think you'll hear is that the Senate doesn't want to become the House. There's an old saying in Washington, it's not Republicans and Democrats that hate each other, it's the Senate and the House. Like, they literally never walk across the Capitol to each other. Senators think that if they get rid of the filibuster, they will make themselves like the House, and my answer to that is no one's eradicating the states. All right? That, we already have deep malapportionment because we have states with 600,000 people, and then we have states with millions of people, double digits, millions of people. And we cannot amend, this is entrenched in our Constitution, we cannot, in theory, amend it. I don't see that state connection going away, which is why the Senate will always operate in different ways than people who represent districts. So the representative of the 5th of Pennsylvania cares about the 5th of Pennsylvania, doesn't care necessarily about all Pennsylvania. Whereas the senator from Pennsylvania will always care about all Pennsylvania because they get their votes from the entire state. So I disagree with those arguments, and I think at the very least we must experiment with this. Sometimes things that you think are good ideas turn out to be bad. So for example, they took away something called earmarks, and now every political scientist in America thinks we need to have earmarks back. So I think experimentation under limited circumstances and equally divided between parties is the only way you're going to get there, soundly. Not some president saying, oh, have my rules.
How about one more question? I know folks have class. One more question. Any brave soul out there? Oh, we got one in the back.
I was just wondering if you
I'm not an expert in the Electoral College. I do think that we've experienced this throughout history where someone gets the popular vote and they don't win the presidency. There seems something deeply undemocratic about that. Again, I think this is the time to do it. You know, Rahm Emanuel always used to say, you know, never let a crisis go unwasted. We got a crisis, and people don't like to talk about structure, so this is the time to start interrogating it and how you would change it. The only virtue to the Electoral College is that presidents must pay attention to small states, right? And so, you know, while you're changing other things in this, like the Senate, I mean, while you're doing it, you have to calibrate the effects on that, and I presently don't know, but I think this is the time to lean in. It seems wildly improbable that we should have a popular vote that is not met with the Electoral College. But the reason we have it, of course, is that the problem that some people see is that you'll get the coasts, which have the most population, and that they will always win. And that will cause a war, just to exaggerate. If I don't exaggerate, no one will know what I'm talking about. Gross animosity between the flyover states. I used to live in one for a long time, so I can say that. And the mass centers of population. You'll have much more aggravation. We already have deep urban-rural split already with partisan gerrymandering. And one problem with just getting rid of it, I mean, it sounds totally plausible, but the problem is whether you will set up sectional or state animosities in a way that actually aggravate current problems rather than ameliorating them. So I don't have any answer, but that's basically an overview of the pros and cons.
All right. Well, thank you so much. Thank you all for being here. Again, we so appreciate everyone's joining in this great event today. I hope it has inspired you in great ways, and we look forward to seeing you again at another event. Thank you again.